Welcome to the North State Breakdown with Benjamin Nowain. Today I would like to discuss the events surrounding the July 23rd Shasta County Board of Supervisors meeting. This subject is particularly personal to me as it involves myself and my wife, Jenny Nowain, who was ultimately forcibly removed and cited for disturbing a meeting under Penal Code 403. CEO David Rickard, County Counsel Joseph Lamore, and District 4 Supervisor Patrick Jones, acting on behalf of Shasta County, not only violated Jenny's right to free speech, but also violated her right to peacefully petition the government for a redress of grievances. There were some major issues with how things were handled during the July 23rd board meeting. During the vote for my appointment to the Elections Commission, the board chair District 1 Supervisor Kevin Cry recused himself.
And at this time, I need to let the board know that I'll be recusing myself from this vote.
Why?
You'd have to ask the applicant. I can't disclose that.
As well as Vice Chair District 5 Supervisor Chris Kellstrom.
And I'm going to take Supervisor Rickard's recommendation. I'm going to recuse myself also.
This left the board without a chair, and when the meeting commenced after a short recess, Patrick Jones assumed the role without due process. According to the rules that Shasta County operates under, Rosenberg's Rules of Order, if both the chair and vice chair recuse themselves from a vote, the remaining members of the body typically elect a temporary chair from amongst themselves to preside over that vote for the specific item. This didn't happen. In fact, this was not only a violation of Rosenberg's Rules of Order. If the decision for who would assume the chair happened behind closed doors, it would additionally constitute a Brown Act violation, as a decision of this nature would require notice and participation from the public. Jenny's peaceful protest was in response to false statements made by District 4 Supervisor Patrick Jones. I had just given a speech about how I wish to bring balance to the commission.
Instead, we should strive for a balanced approach that includes all voices. Our discussions may be passionate and sometimes contentious, but I endeavor to engage respectfully and constructively.
And had previously made a public statement about how I wish to create a mission statement for the commission and help educate the public about elections. Despite this, Jones chose to lie about my motivations.
Never have I ever seen anywhere, and this is coming up to my 12th year as an elected official, both from the city and the county, that someone wanted to be on a committee or commission that didn't have a thorough interest in making it better. Never. Quiet, please, quiet.
While it is within Jones' prerogative to vote as he deems fit, members of the audience were outraged at the mischaracterization of my motives. Jenny's silent refusal to leave the chambers was a form of civil disobedience, drawing from a long tradition of nonviolent protest protected under the First Amendment. Historical precedents such as Edwards v. South Carolina and Brown v. Louisiana are examples that peaceful, symbolic speech is constitutionally protected. Let's take a closer look at one of these pivotal cases, Brown v. Louisiana, which took place in 1966. In this case, 5 African-American men conducted a silent sit-in at a segregated public library in Louisiana to protest racial segregation. They were arrested for disturbing the peace. The U.S. Supreme Court held that their silent sit-in was a form of symbolic speech protected by the First and 14th Amendments. The court emphasized that the men's conduct was peaceful and orderly, and that they were expressing a legitimate form of protest against an unjust law. Justice Fortas, delivering the opinion of the court, stated that the First Amendment protects the right to peaceful protest, and that such actions are a form of symbolic speech. The decision highlighted that states cannot criminalize peaceful expressions of dissent simply because they are unpopular or inconvenient from public officials. In comparing Jenny's situation, her silent refusal to leave the chambers was similarly a form of symbolic speech. Her actions are a classic example of an act of civil disobedience. Just as the sit-in protesters in Brown v. Louisiana, Jenny's conduct was peaceful and non-disruptive. Prior to having multiple deputies forcibly remove Jenny during her silent protest on July 23rd, she had requested to speak with her lawyer, which County Counsel Joseph Lamore refused.
Jenny wants to talk to her lawyer.
I'm sure the police will come and get me eventually, and my lawyer will come then.
She wants to give it. You're refusing to let her lawyer.
So just FYI, our county counsel is refusing to let a lawyer see his client.
On what grounds? Why can't the lawyer go in? What legal doublespeak would keep the lawyer from going in?
This may violate the Sixth Amendment, right to counsel, the Fifth Amendment, the right against self-incrimination, as well as the 14th Amendment, due process. Lamore's refusal to let Jenny speak with her lawyer undermines the legal protections designed to ensure fair treatment and a fair trial. Ironically, Patrick Jones was part of a disruptive mob on January 5, 2021. In his very first meeting as supervisor, he allowed people into a meeting that the board majority had previously voted to be closed for public safety, a move that undeniably disrupted proceedings. Additionally, back in May of 2020, Alyssa McEwen stood outside the boardroom with a bullhorn, causing a significant disruption.
You're not the first county to take this step, and you certainly won't be the last, but by God, you ought to repeal these stages and return Shasta County to its full and complete functions. Our businesses are on the brink of no return. There is no amount of emergency funding that can save Shasta County.
Now they're leaving. They're getting up and leaving.
Yet she faced no citations. There is seemingly a double standard based on the petitioner's political ideologies. In fact, using a bullhorn is a classic example of behavior that can meet the criteria of California Penal Code 403, which makes it a crime to intentionally disrupt a public meeting. In another incident highlighting the selective enforcement of rules, during a public comment at the May 30th, 2023 Shasta County Board of Supervisors meeting, a man named Alex Bilecki used a racial slur during his speech.
This is wrong. When you devalue someone's house, that's wrong. And I'm telling you straight up, I'm not a fool. I'm not a and I want... That's right.
While abhorrent, Board Chair Patrick Jones allowed Bilecki to finish his speech under the guise of First Amendment rights.
California state law and your California Constitution under the First Amendment. In a public meeting, you have a right under the Constitution, to be loud, to be rude, to be profane. This is all established law in the state of California, and it is a guaranteed right to you under the Constitution of the United States.
Rights that were not afforded to Jenny for her silent protest. Regarding the events of July 23rd, Jones has gone on the radio and insisted that District Attorney Stephanie Bridget fine Jenny $1,000 for her peaceful protest.
Right. They've asked her, many times to please leave. And they said, hey, we could do this the easy way or the hard way. And they had to do the hard way, which was to literally lift her up and remove her out the back door where they cited her. Now it's up to the DA as to what to do. You could put her 6 months in jail, or you could give her a $1,000 fine. That's up to the DA. Now I'm hoping that a fine would be levied, because that's what would teach a person that if you violate the law, which is Penal Code Section 403, that there is a penalty and it's going to cost you some money.
Contrast this with the actions of Richard Gallardo, a citizen who attempted to perform a citizen's arrest on the board in 2020.
I, Richard Gallardo, exercising the authority vested in me as a citizen of the United States, as a citizen of the state of California, and California Penal Code 837, do hereby arrest the following persons for multiple California Code violations, using false and misleading pretenses and calling it a threat to public services or facilities.
Thank you, Mr. Gallardo. 3 minutes.
I am arresting you, ma'am, in Penal Code 837. There is no 3-minute mark. You are under arrest. Okay.
Under California Penal Code Section 837, a private person can arrest another for a public offense committed in their presence, but doing so without legal justification can lead to charges of false arrest. False arrest under California law can result in both civil and criminal penalties, yet he faced no legal repercussions. The events of July 23rd ultimately led to the introduction of new media policies. On July 26th, a press release announced that the media are requested to observe and document the Board of Supervisors meetings from a designated media room and must vacate the boardroom without re-entry during disruptions. A second press release was sent out on July 29th, stating that media members have the option to observe from the media room. During the July 30th meeting, where the media policy was discussed by the clerk of the board,
Members of the media who want to observe, record, or otherwise document a Board of Supervisors meeting are requested to set up equipment and attend from inside the media room. Any member of the media opting not to attend through access to the media room will be considered participants in the Board of Supervisors meeting and may be asked to vacate chambers in the event of a disruption.
CEO David Rickard tried to clarify.
The decision was that if we have to clear the room for a safety reason and shut down the board meeting, everybody will have to leave the board chambers, including the press, as an accommodation to provide an additional opportunity for the press to remain. We decided to open the press room so they wouldn't have to leave. So it was an additional accommodation that didn't exist before. I want to clarify that. The sheriff did not limit the press in any capacity.
Neither have we.
Correct.
Well, what we've done.
Neither are we.
What we've done is we've actually, and actually I'm going to let public comment finish.
However, Supervisor Mary Rickard questioned this.
I have a question for County Counsel, I assume. You know, the first I heard of this change of having the media go into the media room was when it came out in the press. I was not part of the decision. Who makes that decision, and what does that process look like?
Sheriff made that decision.
Sheriff wrote that policy?
We don't need anything from the crowd.
The public wants to know.
Go ask the sheriff.
However, Sheriff Johnson later refuted this claim, stating he had nothing to do with it and that the policy complicates the sheriff office's safety plans. Additionally saying, "I will not be drugged into the frivolous politics and bickering." This conflicting narrative raises serious questions about transparency and accountability from the Shasta County Board of Supervisors. Then, on August 1st, a third press release was sent, rescinding the media policy, stating that based on media, quote, misreporting, they would rescind the media room option. But this did not address the other half of the policy, which restricts the press's right to remain in the room during a disruption. Cry's allegation that the media misreported appears disingenuous. Cry and CEO Rickard attempting to interpret the press release as an option rather than a mandate is misleading. The subsequent retraction and Cry's reframing of the confusion caused by the press release as misreporting suggests an attempt to hide the truth. It appears as if no one wants to take credit for this policy, and rightly so, as it appears to violate the freedom of the press. The First Amendment Coalition already issued a legal warning, asserting that this policy runs afoul of the Brown Act and First Amendment protections. The First Amendment Coalition's warning letter emphasized that the media are essential to keeping the community informed, especially during public meetings. Restricting their access undermines our democracy and violates both the Brown Act, which ensures public access to government proceedings, and the First Amendment, which protects the freedom of the press. Finally, let's also consider how the Brown Act relates to Jenny's actions and Penal Code 403. The Brown Act is California's open meeting law, ensuring the public's right to attend and participate in meetings of local legislative bodies. The Act aims to promote transparency and accountability. Under the Brown Act, the public has the right to observe meetings and express their views without undue interference. Penal Code 403 targets disruptions that, quote, substantially interfere with the conduct of a meeting. However, Jenny's silent protest didn't involve loud or physically disruptive behavior. Instead, her peaceful and silent protest was a form of symbolic speech, protected under the First Amendment. The substantial interference in this case was arguably caused by the official's reaction to her presence, not by her act of sitting silently. By citing Jenny under Penal Code 403, the authorities potentially violated her First Amendment right as protected by the Brown Act. Her removal from the meeting not only trampled on her rights, but also set a concerning precedent for the treatment of peaceful protesters. And that's the breakdown.